Okay, so since you two are getting married, I decided to tell you a secret. That is, back in the time of SARS when the property price is real low, so I bought a house for my daughter in case the price will surge one day. So now you see the property price is really spiraling. So how smart am I?
Oh, you're the best mom in the world. Where's the house?
It's in Two Moon.
Two Moon? Excuse me? I'm working in Central. It's time consuming to travel between Central and Two Moon. Actually, Shogun and I have been saving money. If we sell the house and use the savings, that should be enough for a flat in Tycoon.
But then the price in Tycoon is really high, and then the area of living is really small. It's not worth it.
Wait, don't you understand? It's about accessibility and convenience.
I don't know.
I don't know.
But all I know is I'm taking everything for granted. If there's that house, I'll file lawsuit against you.
Yo, you know what? Ask for your opinion, you annoying old. Let's go, Snowfall.
The plaintiff told us that there was no express trust, so now we turn to consider the matter of implied trust. In Hong Kong, when a father buys a house for his child without any prior arrangement of where the money will go if they do sell the house in the future, do you think the law will allow the child to keep the money from the sale in the future?
Yes.
Yes. And more?
And what if it's a mother who bought a house for her child?
Yes.
Let us ask Ms. Love Landlaw, a land law professor at Papulam University, about the correct legal position of it.
So in Hong Kong, according to the Risu per Yu case, the courts would only resort to the presumption of advancement when there is no acceptable evidence of the purchaser's actual intention.
So you mean if the evidence does not suffice the court in finding the purchaser's original intention, such as whether the purchaser at the time of purchasing the property intends to be benefited from the future sales of the property or not, then the presumption of advancement comes into play.
Yes, the traditional view of Hong Kong can be traced back to an English case, Bennett and Bennett. The law presumes the male's intention to have bought the property as a gift, and the person receiving the property is entitled to sell the property and keep the money. On the other hand, there is no such recognition of the traditional view in Hong Kong law if it was a female who made the purchase to her husband or her daughter.
As Carlyle is a mother to Smokeball, does that mean there is no presumption of advancement in Carlyle and Smokeball's case?
You would be correct under the traditional view. However, Australia has already declared the presumption of advancement to be equally applicable to both fathers and mothers. In a 2008 Hong Kong case, Li Fong and Kwok Wai-sun addressed
Law
that.
is living and flexible. As time and socio-economic conditions change, the common law also changes. It must be presumed in the absence of evidence to the contrary that when a mother purchases property and transfers it to her child, a gift of the property to the child is intended. The principle in Bennett and Bennett is now out of date.
That means Smokeball, by the presumption of advancement, is entitled to sell the property under her name and get the money from the sale to invest in another place she wants?
As said, according to the Risu per Yu case, the courts would only resort to the presumption of advancement when there is no acceptable evidence of Carlyo's actual intention, so don't abuse the presumption. If the court accepts Carlyo's evidence that she intended to make Smokeball a trustee, Smokeball would be a trustee. Remember, evidence first, then presumption. As Smokeball is a trustee, she cannot sell the property without obtaining Carlyo's permission and keep the proceeds on her own. More importantly, Smokeball is already an adult. She was only financially dependent on Carlyo when she was small. Carlyo's moral obligation to take care of her daughter has ceased to exist. According to the Shin Shu Tai case, the presumption of advancement won't apply to an adult child.
Thank you, Ms. Love Landlaw. Remember, no matter what will be the outcome, it is not worth ruining a parent and child relationship over a non-living property. Law cannot mend relationships, but love can.